This is the first time, to my knowledge, that this has occurred.
That is true, Judge Middleton. There has been significant debate over this in the landlord community. According to the Fair Housing Agency Handbook, pet rules do not apply to support animals. Housing providers may not limit the breed or size of a dog used as a support animal just because of the size or breed, but can limit based on specific issues with the animal's conduct. Experts in landlord-tenant law routinely say no one really knows if restrictions can be placed on emotional support animals because no one has challenged it in court. Until now, it appears our own Judge Middleton, without knowing it, is about to hear a precedent-setting landlord-tenant case that will likely end up before the Supreme Court eventually. And it all starts here on Adventures with the Tizzos.
Good morning, everyone. This is Judge Middleton here at the courthouse in Centerville. Miss Webster, are you still with us?
Yes, I am.
Miss Webster is here. I went through her rights with her. She was here early. Well, let's call this case. This is Memory Lane Mobile Home Park versus Tiffany Webster. The file number is 23632LT. Miss Webster is here, although I can't see her right now. Attorney Stuart Weiner from Southfield is here on behalf of the park. Now, Mr. Weiner or Mr. Weiner, there are two ways to say it. There was a family here in Three Rivers, and the law firm was known as Weiner, Wade, and Tucker. But when his son went to be a professor at Cooley, he was known as Professor Weiner. So do you say Weiner or Weiner?
I say Weiner, but thank you for recognizing both pronunciations.
Well, Professor Weiner was there for a long time, very well liked. His father, Leonard Weiner, was the dean of the St. Joseph County Bar Association. He lived to be about 100 years old. All right, here's Miss Webster again. And Jeffrey Clay is here on behalf of the defendant. Good afternoon, Good morning, Mr. Clay.
Morning, Your Honor.
This matter is a not simple termination of tenancy action where the park wishes to terminate this tenancy. Mr. Clay has filed an appearance on behalf of the defendant and requested an adjournment. And rather than adjourn it, I thought, well, we'd set it for now and then figure out where we put our next hearing. Miss Chris Corpening, the manager for Memory Lanes, has just logged in. For many years, Mr. John Bush has represented Memory Lanes. Ms. Corpening, is this a change of policy, or is Mr. Weiner here just on this complicated case?
On this because it's complicated, Your Honor.
All right. All right. This has to do with pit bulls or any other animals. So, Mr. Weiner, what's the premise here?
Well, the premise is, Your Honor, that Ms. Webster signed an agreement as part of obtaining her mobile home park lease, and she did that in 2018. We attached the agreement to the complaint, and her counsel has received that agreement. In that agreement, it says pet agreement and rules. All pets must be pre-approved by management. And it says under dog, the following dogs are not allowed: chow, pit bull, some others, or a mixture of any kind of above breed. The rules also state there's a maximum of 2 pets allowed. There are also in these rules, pets are not allowed to run loose in the community. There's also a rule that you have to have homeowners insurance to provide liability insurance to cover dogs. There are regulations. And the first problem with Ms. Webster was that Ms. Webster, when she signed the agreement, you'll notice, because Ms. Chorpenning signed the agreement as well, she represented she had a cat. There were no dogs that were represented to the landlord. Subsequently, she obtained dogs. When she obtained dogs, it was represented to the landlord that she had obtained a husky dog. There was no mention of pit bull. She had 2 dogs, and those 2 dogs subsequently mated, and 4 more dogs were produced. Apparently, Ms. Webster was able to either transfer, dispose of, someone has them, but 2 of the 4 puppies were no longer with her. So she currently has 2 adult dogs that are over 3 years old, probably 3.5 years old or so, and two puppies, which are a little over a year now. This is problematic on numerous fronts. One, it's a pit bull. And by the way, we did not know that it was a pit bull until we received an alleged letter that states that in support of an emotional sport animal dog, not dogs, not 4 dogs, but an emotional support animal letter. In that letter, it represented that there was a husky pit shepherd mix for each of the 4 dogs, which was in violation of our rules. Wasn't disclosed to us ahead of time. It didn't. She never let us know that there was a pit bull involved here, and we were caught off guard and immediately started talking to Ms. Webster about her options, which is she can remain as a tenant in the community mobile home park, but she has to remove the dogs, or she can move, or we would even consider purchasing her mobile home park. She has paid for her mobile home, by the way, in full. There had been an issue about transferring title. We learned about it after the complaint was filed. We've now remedied that. We have, in fact, started the process of transferring title. So Ms. Webster is going to own her home. Shortly, she'll get a letter from the Secretary of State receiving the original. But the problem is there have been issues. She lives in a 1,200 square foot mobile home. She has 4 animals. 2 are 54 and 64 pounds apiece, and the others are puppies. She has a boyfriend. She may have a cat. So we don't know if it's even healthy in that mobile home park. We understand that she has a letter that supports her because she has some emotional needs. We're sensitive to that, but certainly there is no such thing as needing 4 dogs for somebody who has an emotional need. And we have a rule that she agreed to in 2018. We would not have leased to her if she had a pit bull and we knew about it. And as soon as we knew about it, we took steps to start the process of removing her. We comply with the Fair Housing Act. We're not trying to do anything to discriminate. I've learned from counsel that allegedly there are some other pit bulls in the area, in our community. I asked for photos and identification of the homeowners. I told him that if we learn about that, we will terminate any homeowners that have pit bulls immediately. We're very consistent about that. Of course, I haven't received any evidence from him that there are any other pit bulls. And I suspect that's because he doesn't want to let us know, because we're then going to start eviction proceedings against other homeowners. We can't tolerate this, Your Honor.
Well, let's hear from Mr. Clay. Mr. Clay, what's your position?
And our position is this eviction is retaliatory in nature. The defendant had hired counsel previous to me in January to send a letter to the mobile home park asking for the tax and title to be transferred after the taxes were paid. She finished paying the lease off of the house, or paid off the mobile home, in October of 2022. That's when these problems started happening. At that point, she started asking for the tax and the title fee so she could pay it and obtain title to the home. The plaintiff refused to give her the amount of taxes and title fee up until she hired an attorney in January of, I believe, January 27th, I believe was the date. Then the plaintiff finally sent the amount of tax and title fee to the defendant on February 20th. The defendant then paid it in March, I believe March 22 of 2023. Again, the plaintiff refused to give the defendant the title to the vehicle or to the mobile home. And so she sent another letter in April through her other attorney stating they demand possession of certificate of title. A week later, this eviction took place. To me, this seems as though the eviction wasn't about the dogs, but rather they didn't want to give title to the client.
Well, let me tell you where I'm coming from. I'm about the dogs. I'm not a fan of pit bulls. I've had dozens of terrible pit bull cases in the 42 years I've been here. And my guess is if there are pit bulls there, the people in the park are unhappy about it. So let's assume everything you're saying is accurate. We still have a safety issue. And the defendant, according to the plaintiff, has not one, but 4 animals that she brought in without the park's consent. They are quote unquote emotional support animals. That's hard to determine, but they're outside the provisions of the park rules and lease. So we've got issues we have to fight about. So we have to figure out where to put this. So it isn't about non-payment of rent. It isn't about maybe other termination issues. It's about termination that has to do with the safety and well-being of the other residents in the park. The rules in the original agreement are quite clear. Plaintiff contends she brought in 2 and then 2 more animals, and now is trying to hang her hat on emotional support. So they give her 3 options: get rid of the dogs, move, or we'll buy your mobile home back and then you can move. So we have a disagreement here. I didn't feel the need to adjourn this because we can figure out where we're going to put the hearing, but this is going to take a while. Ms. Webster, what's your position? Are you willing to give on the number of animals or any of the circumstances?
No, only because I've put money into one of the puppies. She had to get a leg amputated because somebody out here in the park caught her and her leg got broke. And my dogs are not pit bull, they're husky. German Shepherd pit bull, and the pit bull is not probably like an eighth of a pit bull gene.
All right. Well, for one thing, we'll have to sort that out. I'm gonna have to actually see the dogs. But
I could go get one of my dogs right now if he would like to see one of them.
well, we'll save that. But for one thing, you have 4 of them. So it's like, I want an inch, but I'm going to take a mile. And so the park is unhappy about us. So we're going to take tests. But I have your position. You're not willing to give anything. So you want all 4 dogs in violation of the current dog agreement. So we've got other issues. Mr. Clay raises retaliatory eviction questions. And this isn't simple. The problem, gentlemen, is finding a place to put the trial in this matter. There's the 4th of July holiday. Judge Pattison is gone in July. I'm gone in July. Finding a place to put this for like a day-long trial will be difficult.
Can I make a comment about the animals themselves?
Who's speaking?
I am Attorney Clay.
Oh, yes, or Mr. Clay, Jeffrey.
So, my understanding with the FHA, when you have an ESA letter, which Ms. Webster does from her psychiatrist, that the breed of the animal is not to be given deference. It's supposed to be the specific animal itself must be a danger or health concern. And I don't believe that there's been an issue specifically with the particular animal. It's an issue with the breed itself, which under the FHA would be discriminatory.
Well, this is why we're going to have a hearing to take testimony on these issues. And I'm trying to figure out a place to put it. Are you available on Wednesday, August 2nd at 1 p.m.? This would be live here at the courthouse, not by Zoom.
I'm available, Your Honor.
I am as well.
All right, we're going to set this for a trial on the merits on the termination issue for Wednesday, August 2nd. I have a jury trial that day, but I'm hopeful I can juggle both of these.
Your Honor, can I just make a comment, 2 comments about what Mr. Clay said? First of all, the letter was not signed by a psychiatrist. The letter was signed by a limited master of social work therapist. The second issue is that no one is precluding Ms. Webster from getting an emotional service dog. There's lots of breeds out there that she can have that can fall within the province of the of being permitted in the park. Not 4 of them. She can have one, okay. But she chose to get a pit bull, no one else, and that was her decision. And she
denies that it's a pit bull, but
her therapist.
What breed is it, and how many are there?
Her therapist says it's a pit bull. So right. I would assume that her therapist received that information from her, but that, be it as it may. So it's not a question of retaliation. These are all trumped up defenses. It's really a question of compliance with rules that she knew, she signed, she agreed, and she chose to ignore them. And even when presented with reasonable accommodations, which is all we need to do under the Fair Housing Act, she's refusing to do that as well. And finally, by the way, she talks about having to spend some money on a dog that needed an amputation. The reason why that dog needed an amputation was that dog was running loose in the community. Again, a violation. It should have been leashed. The dog ran loose for a couple
and somebody from the front office.
Just a minute.
Yeah, whatever you do.
This isn't the kitchen table. This is a courtroom, and you don't just blurt things out. I'll give you a chance to speak through your lawyer, but
Anyway, the dog ended up having an accident as a result. And again, had you followed the rules and had the dog leashed and not run loose.
all right. Well, I've set aside 4 hours, and I'm not sure that's enough, but that's what I got. And I have a jury trial that morning, and I'm hopeful it'll either resolve or we'll be able to use the afternoon. But otherwise, we're way out, and this is an issue. In the meantime, the dogs are not to be out loose or unescorted. There are, plus you're in a mobile home park. You know, this is on a small lot. I don't know where dogs go there, but those may be issues as well. So we're going to block out 4 hours, and I'm not sure that's enough. We've got issues about psychological assessment, whether she's eligible for an emotional support animal. We got issues about what kind of breed it is. So this isn't straightforward. And if we can't finish it in those 4 hours, I guess we'll have to continue it. But we'll address the matter further live. So, Ms. Webster, any of those additional concerns? Mr. Clay seems to be well on top of this. We can address those. But if we were sitting here in the courtroom, I don't think you would have just blurted out like that. But people tend to let their emotions get the best of them. You certainly will get a chance to testify under oath, tell your side of the story. But the park says this violates the rules. It's not the right breed. You didn't go through the process right. It's a case of asking for forgiveness rather than permission. You got the animal, then claimed it was emotional support. It's complicated because you own the trailer. So there are a lot of issues here. We will address them live on August 2nd at 1 p.m. All right. Thank you all.
Thank you, Your Honor.